The North Gauteng High Court is reviewing South African Reserve Bank and ABSA's plea on the Public Protector's report on the illegal Bankorp bailout. The bid is to determine if money given for the lifeline is still outstanding to the Reserve Bank. The South African Reserve Bank and ABSA want advocate Mkhwebane to pay legal costs independently and are accusing her of abusing the office of the Public Protector. The Public Protector CIX ABSA report found that South African Reserve Bank's 1.125 billion rand bailout of Bankorp between 1985 and 1995 was unlawful. It also said that ABSA, which bought the bank in 1992, should pay back the money. Arguing first, ABSA has taken on the late filing of the answering affidavit by the Public Protector and reiterated that interpretation of remedial action is incorrect. ABSA has also raised questions about the Public Protector's justification of her meetings with the President. Earlier, the judge dismissed an application by Open Secrets to be admitted to place evidence on crimes which have never been investigated during the apartheid era.
Every one of our grounds of review is couched in the alternative as a legality review, and we have referred the court to the authorities in our supplementary heads, which indicate that for a legality review, it is not necessary to show an adverse impact upon rights. It's the Kayalani Ridge case in the Constitutional Court. As we point out in our supplementary heads, the SCA, in the case of SIU versus Madison, has indicated that an inquiry by the SIU, and I quote them, can easily make important inroads upon basic rights of the individual. So the capacity to affect rights by the very fact of an SIU investigation has been recognized. The argument rests upon the Public Protector's interpretation of the remedial action, and for the reasons that I have advanced, we submit that that interpretation is incorrect. If the interpretive argument fails, then of course the prematurity argument that she advances also fails. But assume I'm wrong. Assume that the court were to find that her interpretation of her own remedial action is correct. The point about no administrative action is bad for three reasons. The first is that the proper test, and Justice Fourie will be alive to this by virtue of his judgment in Telkom and in Mkhwebane, which we've added to our bundle, is the test following the Supreme Court of Appeal's decision in Gray's Marine is whether the action has the capacity to affect legal rights. I'm focusing on what the Public Protector has done. And she has unquestionably relied on Dr. Bankorp in manners which we are shortly to submit is, at a minimum, grossly misleading. There are two problems with Dr. Bankorp's report. The first is that it's an attempt at an ex post facto justification, and the second is the question of the admissibility of his opinion, certainly on issues of law relating to the legality of the transactions, in respect of which he expresses liberal opinions, and that, of course, is not admissible.